Welcome back to the Houston Lawyer Referral Service video series, your trusted source for clear, reliable legal information from experts serving the greater Houston community. In this video, we'll be discussing what happens in Texas when someone passes away without a will with your Harris County Public Probate Administrator, Brandon Cofield. Welcome, Brandon. Thank you for doing this video for us. Today, we'd like to know what happens if someone dies in Harris County and they do not have a will.
Yeah, so things get complicated is the best way I can describe it. So as I mentioned, whenever you have a will, typically you're gonna have a person that's named as the executor, and we're gonna know who's supposed to get what. So when you think about the idea that now the court has to decide who's supposed to be in charge and who's supposed to get what, that's a whole different calculus that has to go on. And some of that, I mean, that has an impact on how long the process is. It has an impact on who's who knows who. In short, you still file an application, and like an application to probate a will, you'll be filing an application to appoint an administrator and to determine heirship. So those two things usually get filed together, but they can be filed separately. But to appoint an administrator is who's going to be in charge, and the determination of heirship is who the heirs are. Under Texas law, basically, and as I always say, Texas kind of has an estate plan for you. They make an assumption as to who you would want to get your stuff because you didn't get a chance to make a will. And so the idea is if you're married and you have a spouse, then your spouse is probably going to get your portion of your community property because it's community property state. But if you have a kid that's outside of the relationship that you're currently in, then the idea is that like the separate property will go straight to the kids and maybe not go to the community property will go straight to the kids and not go to the spouse because that spouse and that child aren't blood related. So there's just a lot of different nuances as to what the court's following the law, but the law lays out who gets what, when, and where. If you're a single person, it's like, do you have siblings? If you're a single person, are both of your parents still living? Like, or if you're a single person, but you have separate property, but I mean, there's just every type of scenario is pretty much covered inside of the law.
It sounds very complicated if you don't have a will.
Yes.
So if you don't have a will and someone passes away, do you need to hire an attorney to help you file those documents you were talking about earlier so that this process can get moving?
Yep. So just like whenever there is a will, you have to file an application. You have to have an attorney do that. When there's no will, you have to file an application. You have to have an attorney to do that. There's only a handful, really not even a handful, like 2 different documents that are commonly used in probate that you don't have to hire an attorney. But generally speaking, you're going to have to hire an attorney. And the biggest reason why is, I mean, if you think about the possibility of fraud, right? If you have, let's say there's 3 siblings and 2 just can't stand this other sibling. If you could go to court on your own, the court doesn't know your family, you know? So if you can go to court and say, yeah, there's only 2 of us, give us everything mom and dad had. And the court says, all right, well, since you came up first, here you go. You know, now you have a whole nother sibling that's obviously been cut out and they're going to want, it wouldn't be fair. So as much as people don't want to pay attorneys or want to have to deal with attorneys, it gives the court appointed person, it also allows it to go smoother because the court's interacting with a party that's not currently grieving or a party that's not so emotionally invested in what's going on, so that the business side of this kind of tough time can be taken care of.
So not only does it make it emotional when someone passes away, if they don't have a will, the loved ones have to go through additional cost, it seems.
Yeah.
So why does probate take so long when there's not a will?
Yeah, so the biggest piece is that we have to figure out who is supposed to get what, right? It's a little bit easier to decide who can be in charge. There's like a hierarchy, if there's a spouse or a kid or whatever. But when it comes to who's supposed to get what, that's when things get a little bit interesting because the court can't assume that someone is someone's child or is not someone's child. So ultimately, the court is going to have to hire what's called an attorney ad litem. And so, or appoint an attorney ad litem that gets paid by the applicant. So that fee is $750.
Oh my.
And that attorney ad litem their job is to serve as the representative for any unknown heirs. So the court receives the application saying, here are the children, here's the relatives, here's the heirs. And then the court appoints someone to say, all right, let me double check and make sure you're telling the truth. So they might ask for birth certificates or they might ask for obituaries and different information like that. And ultimately, everyone is going to have to come before the court. You have the two disinterested witnesses, two people that aren't going to inherit anything, that are saying, this is true. These are, for example, these are all the children. The attorney ad litem is going to have to sign off and say, yep, I'm satisfied that they give enough supporting information that these are just the children, for example. And then everybody has to go to the court, and then you have the prove-up hearing to establish to the court satisfaction that, yep, these are who the heirs actually are. And then they're going to have to put that, they say reduce it to writing, but they're going to have to, everything that was testified to is going to have to be signed and notarized and then also filed. So the court has as many safeguards in place before they say, yep, you guys are the heirs, because obviously the court wants to get it right and not leave anybody out. So that's why it can take so much longer, because the attorney ad litem is going to have to contact the heirs and do some research and make sure that these people are saying the same thing. I've had horror stories where everybody knew this was this person's kid, but the person didn't sign the birth certificate and there's no other information, or there's no living relatives around anymore that can testify that they knew him and they knew that this was the person's child. So it's so much easier when there's a will. You get a will, make sure it's written correctly and it's done correctly, then there's no question about what you wanted to happen. Because otherwise you could end up with an estranged sibling that gets everything, even though you haven't talked to him 50 years. It's like, that's still your next of kin. So Texas assumed that's who you'd want to give it to.
Very, very important to have a will. And a lot less expensive just to have a will drafted. Yes. And how much does it generally cost to hire an attorney to do a will?
Ooh. Yeah, so I think obviously the numbers kind of change, but I think that a good, reasonable amount is going to be somewhere in that $500 to like $1,000, $1,500. It can be more complicated based off of what you want to do. The idea when you're looking at a will, you're ultimately giving, the whole idea is like a bequest, like you're just giving this to somebody. But as I mentioned, there is certain language that can have an impact on how things get done. So,
well, hopefully with this education that the Harris County Public Probate Administration office is putting out, I know you guys have a lot of programs at different precincts that people can come to live and hear you guys speak. And with these videos, hopefully people in Harris County will realize the importance of a will and get one drafted. So the probate courts won't be so clogged up, and everybody will get what they're supposed to get from their loved ones. We really thank you for your time here, Brandon, and we're going to also stay tuned. We're going to do a third video talking about some things you can do to save money and time, such as TODs, transfer on death deeds, PODs, payable on death when you have a bank account, and things of that nature. So stay tuned and watch the next video.
Sounds good.